intermediary question, and that's the following. Could you explain in this Irish case or in this case of RMT how industrial action and legal action is combined, or how trade unions can support the legal case, and how the legal case can support the trade union case that you explained already? Which kind of industrial action is useful during a legal case? And maybe as a last question, can a legal case also be counterproductive for a trade union case or for an industrial action? What's your experience in these cases? For instance, in a strike case, I suppose there is industrial action, there is this legal action. How is this interrelationship between both sides?
Well, when you're dealing with the international courts, tribunals and committees and so on, of course, the industrial action is by definition over. I mean, most industrial action is very short term. There's not many strikes like the British miners' strikes that lasted a year. Very few go on. So you're normally litigating over a situation which has been resolved one way or another, either by the defeat of the workers or some compromise to the industrial dispute. But what you're challenging is a legal ruling, which may have precluded or may have prevented industrial action at the time. So it's invariably after the event. So what you're trying to do is to broaden the field for the future, so that strikes of the kind that your legal action is based upon can take place in the future. So the RMT case, in the RMT case, the factual challenge, the facts on which the legal challenge in the European court were brought was that there had been a ruling by a British court prohibiting industrial action of a secondary nature. Actually, I'm not sure that's right. That was it was so obvious that the action couldn't go ahead. We didn't bother to challenge it in the courts. What we challenged was the status of the law, which explicitly prohibits in strike action. And we complained because the union couldn't support its members who wanted to take industrial action to improve terms and conditions.
I fully understand that on an international level, the action, the strike action or any other action is over. But maybe also for people attending the webinar, it would be useful that you give the example just in the UK then, even though the legal system is completely different, but to give an insight in this relationship between the lawyer and the industrial action in the beginning, at the very beginning of the litigation and of the strike action, how both avenues are combined at best, and what's the role of the trade union also in support of this legal action.
All right. So what usually happens is that the lawyer, I'm sure it's the same with you in Belgium, but what usually happens is that the lawyers are brought in when the union is contemplating taking industrial action, and the lawyers are asked whether taking that industrial action will be lawful or not, or what sort of challenges, what sort of legal challenges might be brought, and how best can the industrial action be protected against those challenges. Yeah, that's normally what happens, and usually you can offer some indication of what the level of risk is by taking this form of action or that form of action, calling on these workers to take a strike to go on strike, but not those workers, these workplaces, but not those workplaces, and so forth and so on. I mean, the British strike law is so complicated that it would be a very foolish union that didn't consult its lawyers first. But what happens from time to time is, of course, they call in the lawyers and say, how do we best protect the union? And the lawyer advises and says, do this, do that, do the other. And then somebody on the ground does something on behalf of the union, which is legal advice has not been asked for.
Mhm.
And then sometimes things go wrong. And unfortunately, that does happen. And we lost, we had an injunction, a court order against the strike in the post office 18 months ago, which I defended the union, but some tactics had been adopted, which on which I hadn't been consulted, and unfortunately, we lost the case in the Court of Appeal. It was very unfortunate because we had an absolutely overwhelming ballot in favour. I think it was over 90% of 110,000 members who'd voted in favour of this action. So very disappointing. But I mean, of course, you can't foresee everything, and I don't blame the union officials at all, and no doubt the lawyers too overlook things as well, but you try not to.
I think that sorry to interrupt, that in Belgium often, and that's a useful confrontation, that as we have a quite liberal strike regime, we often have to say, okay, we don't know what will happen afterwards, so you just do your action, and then we will see what it gives. Of course, you can give a certain advice. That's one thing, but the other thing is, of course, that there's a law and there is the reality in the field, as you have explained too, and that often the reality in the field and the power relationship is predominant, and so they can go further than what the law authorizes. Is that also something that you have noticed or experienced in some cases?
Of course, if the workers feel sufficient collective strength, then they just simply walk off the job. And very wisely, don't consult the lawyers. Quite right, because the lawyers would tell them it's unlawful. So why ask the lawyers? Just get on with it. But of course, in order to do that, I mean, it's important that in order to do that, you need a workforce which feels its own collective strength and is angry enough at the way they've been treated or their representatives have been treated to do it. And of course, that is not the situation for the vast majority of workers in Belgium or in Britain. Most workers don't have that strength. They can't possibly afford to take on the employers in that way. And the more unskilled and the worse paid and the worse treated they are, the less strength they've got, because they are disposable. The employer can just sack them and bring in new workers. So it's a very, yeah, we'd all love the situation where workers were strong enough to do that. But
that brings me to this question that if a legal procedure is started or litigation, what's your advice to trade unions in the sense, can they do something to bring awareness on this court case, but also on the problem beneath the case where you're fighting for? What can they do to support this legal case?
I think that depends on the situation in every case. Unions obviously use the fact of litigation after a dispute is finished to demonstrate, or even while the dispute is going on, because sometimes you get employers seeking court orders to prevent a strike which is already taking place. unions obviously use the fact of the litigation to demonstrate to their members and to the wider public and to other employers that they're prepared to fight in the law courts as well as in the workplace for their rights. And that's an obvious strategy for every trade union, and they should have a press relations team ready, willing, and able to do that. But also, of course, there are other tactics that trade unions can take, which don't necessarily support the legal action, or they may in fact be an embarrassment for the lawyers who are arguing in court, but nevertheless are quite powerful. For example, one union in particular in Britain has a sort of a strategy book, which involves all sorts of actions, such as picketing the houses of the directors of the company, or where there's one person who is the primary owner of the company. In one case, a couple of years ago, they organized a protest march in the village in which this chap lived in. And that was so embarrassing for this man. And to have pickets camped outside, blowing horns, or 24 hours a day, 7 days a week, neighbors complaining about it and so on, that it had an impact on the outcome of the industrial dispute. In fact, it had a better outcome than the litigation that we were conducting did. So yes, I mean, obviously there is an interaction between, and inevitably between the workers in dispute, and the leadership of the unions and the lawyers as well.
Okay, very well. So I just give you the opportunity and the floor to add something if you want to stress some elements, or if you want to bring a case that you think that is of particular importance on this issue of strategic litigation, or that you want to conclude. It's as you wish.
I think on strategic international litigation, that the thing is that it's important to talk to colleagues internationally about this, because the stakes are so high that really you know, if you're taking a case that could affect every worker in Europe, that's a huge responsibility. So you've got to be sure that either you're going to win, or the case is worth fighting even if you lose. So I think that those strategic considerations are very important. That means a legal assessment which shared amongst those few of us that practice labor law at an international level, and also, of course, amongst the trade union federations operating at European or international level. These are not decisions for the lawyers alone. They're not even a decision for the national unions. These are decisions that have got to be, of course, we know the internal politics of the international trade union movement and so on. Those have to be taken into account as well. But it's important to have conversations with at union leader level internationally as well, if these cases are going to be taken, because of the significance that they have. And of course, you know, the politics of these international bodies, we touched on it earlier. And obviously, we haven't got time to go into the detail of the political machinations of the International Labour Organization and so on. But all that's got to be factored in as well. You've got to know what the political leanings are, the political pressures, the personalities who will be involved at international level. And there are people that know that we all have colleagues who serve in those bodies and who know people that work in those bodies. So all that has to be assessed as well before these cases are taken.
Okay.
And there's a lot of academic writing about it, as you know.
Yes, yes, indeed. Okay, I think it's a very good conclusion. Thank you very much for this insight, for your thoughts about strategic litigation and this very interesting talk. Thank you.
Pleasure.